All right, so thanks for joining today. We're going to talk about two things, conservatorship and something called supported decision making, which some of you may or may not have heard of. Um, let's just start ground zero. What is a conservatorship? Conservatorship became very, let's say, in the public eye with the Britney Spears situation not so long ago. Um, and due to that, there have been there's been new legislation and some things have changed. I've been giving this workshop for a while now, and there actually are some things that have changed since I started. So the basic idea of conservatorship, though, stays the same, which is when you have an adult that cannot provide for their own needs for food, clothing, shelter, medical care, they cannot make sound decisions on their own, then sometimes that person would be eligible for conservatorship, which means you go to court and a judge appoints someone else to be in charge of making important decisions for that person, such as where they're going to live, what type of medical treatment they receive, what school they attend, those types of decisions. This only applies to adults, and an adult in California is someone who is 18 or over. Okay, so what happens is, your child who may have a severe developmental disability, a severe severely cognitively impaired, when they turn 18, they become an adult, and then they are legally supposed to make all their own decisions. And if you, as their parent, want to be able to continue making the decisions you've been making as they were a child, then you would consider conservatorship as an option. Okay. Within conservatorship, there are two types. There are technically more than two types, but the two main types that come into play the most often are general conservatorship and limited conservatorship. General conservatorship usually applies to the most common examples are someone with Alzheimer's or dementia, someone with a traumatic brain injury, okay, someone in a coma, those types of situations. Those are going to be general conservatorship matters. Limited conservatorship is specifically for individuals with developmental disabilities. So that's what we're going to discuss today is limited conservatorship. Now, I usually say it's called a limited conservatorship because when you go to court, you actually have to ask to have permission to make specific decisions. So the court is going to look at the decisions you'd like to make for that individual and decide if that's appropriate to remove those decision-making rights from the individual and place them in your hands. Now, very quickly, I'm not going to get into this, but some people do need information about mental health conservatorship. And that is something called LPS conservatorship, and that is a completely separate category. That is not what we're discussing today. So if anybody is looking for information about forcing psychiatric treatment on somebody, that is through an LPS conservatorship, and that is separate from what we are discussing today. Now, within the conservatorship, we have conservatorship of the person and conservatorship of the estate. So if you have a conservatorship of the person, that means that you are making decisions about their personal daily care and needs. Where will they live? Where will they go to school, or what programming will they be enrolled in? What type of medical care will they receive? All right, so those types of daily care decisions fall under a conservatorship of the person. Conservatorship of the estate would mean that you're managing their finances. All right. And these are separate. So you don't have to have both. You could just have one or the other, or you could have both together. Okay. So usually the majority of my clients have a child who does not have any assets to manage. Maybe they're going to receive public benefits, or they are receiving public benefits, but that's it. So in that case, that would just be a conservatorship of the person. If you have public benefits and you want to be able to manage those for your child, then you would become something called the representative payee through the Social Security Administration. And information about rep payee is down here on this slide. Or you can just Google representative payee, and there's a lot of good information about that. Okay, so this is always the hot button topic, right? Like, do I need a conservatorship, and what are alternatives to conservatorship? So no, obviously, easy yes or no to this question. It's very case by case. I do like to give examples, though, of these are extreme examples, to be clear, of situations that required conservatorship. Okay. So, for instance, a client whose daughter was 30 years old, had the cognitive functioning of roughly a preschooler. She needed a basic cataract surgery on her eyes so that she could see. And the hospital refused to perform the surgery because they said that she was unable to give consent because of her, incapacity. But the parents were not allowed to give consent because she was an adult. Okay. So they were just stuck in limbo until they went and got a conservatorship, and then they could provide paperwork to the hospital showing that they had the legal right to make the decision about her medical treatment and that she could have the surgery. Okay. So medical treatment is an extremely common one. Other example, a woman who was living in an apartment with supported living services being provided through a regional center vendor. And the services she was receiving were very subpar, very subpar. They were not caring for this woman appropriately. And the family wanted to change vendors, but she was very opposed to change herself. She did not want new staff brought in. And so she was refusing. And so the regional center has to honor her wishes because she's the client. And so the family had to go through the conservatorship process in order to be able to work with the regional center to bring in a new vendor so she would receive better care. Okay, so those are some examples of obstacles people run into. Now, let's talk about what are some of the alternatives if you don't think conservatorship is the answer. Well, if you have an individual that is able to make some decisions with assistance, then there are options. So, advanced healthcare directive for medical decisions. I'm sure many of you have signed one of these. Hopefully, all of you have. That says if something you're incapacitated, then you've designated that someone gets to make your medical decisions for you. Well, you can have your child sign a healthcare directive and they can place you in charge of medical decisions now. Okay, so that is an option. Everyone always says, what about power of attorney? Well, power of attorney really generally applies to, your finances. So yes, if they have finances that need managing, they can place you in charge of those finances. Release of information, the regional center, the schools, any programming they're involved in, HIPAA release forms with doctors. Okay, so these are all versions of release of information forms that the child can sign so that when they turn 18 and their records become confidential, then you can still have access to their records and information. So the child just signs a form with that agency or medical provider or whoever it is that says that you are allowed to have access to their records. Okay, now that doesn't give you any decision-making authority, but at least gives you information. And then supported decision-making. So this is a very, very good option for some people. Supported decision-making is new. This was actually basically in response to the Britney Spears situation. So what happens with supported decision-making is this is not through the court. Okay, so that's the first thing to understand. Big difference. Conservatorship, you go to court. Supported decision-making has no court involvement. All it is a written agreement, a written formal agreement between the individual that needs assistance and people that they designate to help provide support in their decision-making process. Okay, so what does that mean? That means the child can say, I want help making decisions. I'm still going to be the one that gets to make the decisions, but I want to designate some people to be my supporters, is what I call them. And they get to have access to all the information. They get to sit in and on meetings. They get to be part of the conversations with professionals to help me make a good decision. Okay. Now, so what this is again, a written formal agreement where the individual names very specifically people that will be their supporters. Okay, that's written into the agreement. And then they write out exactly what types of decisions they want help making. Do they want help making the decision where they're going to live? Do they want help making decisions with what type of job they'll hold? Do they want help making decisions with what type of medical treatment they receive? Okay, so they get to choose what type of decisions they want help with, and then they get to designate the people that get to help make those decisions. And then those people will always be allowed to have basically a seat at the table, collect information, and then help the individual weigh options and come to a decision. The supporters don't have any actual legal authority to make decisions. Very important to understand. The individual still holds the legal right to make decisions. Okay, as opposed to conservatorship, where the individual does not hold that right anymore, and the right to make decisions is in the hands of the conservators. Okay, now where can you learn more about supported decision making, and how can you come up with a supported decision making agreement yourself? There are amazing resources online. So you can just Google ACLU supported decision making, and they have a whole section of their website dedicated to this. The ARC of California has some excellent video modules specifically about supported decision making. And then there's an entire website, supporteddecisionmaking.org, that you can check out. They also, ACLU and supporteddecisionmaking.org also offer templates that you can download and use and fill out with your child and have them sign. Okay, you're always going to want to have a document like this notarized to make it extra official. And so that is a great new alternative. This has been signed into law in California. So this is a great new alternative to conservatorship for individuals that can make safe and sound decisions, but need help doing so. Okay. All right. So let's go back to conservatorship now. Let's say your child supported decision making is not an appropriate alternative for them, and you need the whole conservatorship route. What does that look like? How do you go through the process of obtaining one? So let's talk about what you can request, what decisions you can make under a conservatorship. So you can request these seven. These are 7 decision-making authorities that the law allows you to request. Now, whether all of them will be granted to you by the court, that's, we don't know, but this is what you're allowed to request. Okay. So deciding where they live, having access to their confidential records and papers, entering into contracts for them, consenting to medical treatment, making decisions about their education. And then these 2 last ones are a bit more controversial: controlling their social and sexual relationships, and consenting or withholding consent to marriage. Okay, so those 2, some courts and some judges do not like to just grant those easily. They want a very, very specific reason why those are necessary. Other judges aren't as strict about it. It just depends on the situation. But just putting it out there that those 2 aren't just always so easy, depending on what county you're in. So let's just quickly talk about a conservatorship. The purpose of it is not to put a parent in charge of a child's decisions and then just let them, take over and do everything and give the child no agency. Okay. The idea is courts want to see parents that are using the conservatorship to navigate obstacles they face in trying to get their child the best medical care, the best social services, enrolled in the best programming, all of this intending to have them be able to be the most independent version of themselves they can be. Okay. So that is the idea behind it. And courts do not love seeing helicopter overbearing parents that, completely take away all, they want the child to be part of the decision-making process, even though obviously the decisions, the legal right to make the decision fall in the hands of the parent. So hopefully that makes sense. All right. So let's talk about quickly the standard of proof. So in the probate code, there's, a standard of proof outlined, which is very, very bare bones, I would say, very broad. And it's just if the individual cannot provide for their own needs for physical health, food, clothing, or shelter. So that is a very broad standard. I mean, I once had a client, he was so funny, and he said, my typical teen, neurotypical teen can't do that stuff either. And so it is a very broad standard, but you'll see when we walk through the process together that there are many checks and balances in place to make sure that you are not conserving someone that should not be conserved. Okay. Now, who acts as conservator? So usually it's the parents, right? That's the most common example. And yes, parents can serve as co-conservators together. Now, when you have co-conservators, it's very important to understand that co-conservators share completely equally, they share decision-making rights. So there's no one parent that gets to make decisions over another one. Okay. And so they share equally, share the decision. If they can't come to an agreement and things get hairy, like you could end up back in court, right? But ideally, that almost never happens. So, but that's just something to consider. Sometimes, you'll have one parent and they'll say, well, what's going to happen to me down the road? I want to have something in place. So maybe they'll appoint a sibling of the individual to be co-conservator with them, for instance, so that then there'll be continuity when something happens to the parent. Okay, so yes, you can have co-conservators. It's just important to know that as soon as someone is a conservator, they have all rights to make decisions. Okay, there's no backup conservator, there's no secondary, none of that. All right. Okay. So let's now talk about the process. What does setting up conservatorship look like? I always start here with people with something called the capacity declaration. This is paperwork required by a doctor because a doctor has to weigh in and say that this individual lacks capacity and make assessments of their cognitive functioning and say that they're unable to make their own medical decisions, since one of the things that you're requesting is to make medical decisions for this person. So, this just changed in January. As of January 1st, there are new forms for capacity declarations, okay? And it is a slightly different process now. The form has definitely become longer. That's one thing. Now, in the past, what I would do is I would tell someone, make sure your doctor is going to fill this out. Once you know they're going to, or I would say, go have the doctor fill this out. When they filled this out, come back and then let's start working together. Now, the way the process is supposed to work is you are actually supposed to have the doctor fill out this form once you have started your case and filed your case so that you can present them with the petition you filed and they have it in their hand when they are completing this paperwork. Okay? That's an important differentiation. Now, again, this is brand new. I have not gone through a whole case yet since January 1st because cases take at least a few months. So I do not know yet if that is true, that they are not going to accept a capacity declaration that is completed before you have filed your case, right? So that is, yet to be seen. But I would say in the very least, you're going to want to give a capacity declaration to a doctor, discuss it with them, make sure they're going to fill it out, even if you want to wait till you filed your petition and then, move forward with the other paperwork. Now, this form you can Google it right now, just write capacity declaration, GC335, and you'll see it. And there's a lot of questions where the doctor has to go through and make indications about the level of impairment in certain cognitive functions. Such as, just some examples, short-term memory, long-term memory, abstract reasoning, logical thinking, things like that. So now it's very important to know this has to be completed by a California licensed MD. So, a physician, a psychologist, a neuropsych, whatever it needs to be, but it needs to be a California licensed MD. And they need to fill out the form in its entirety. Now, there is now also something called an everyday activities attachment. This is optional, but it is very useful for your case. This can be filled out, and there's a long list you see here of who can fill this form out. It doesn't have to be an MD. It could be, there are a variety of professionals that can fill this out. And this basically this shows everyday activities and the individual's ability to complete them either with no assistance or, needs full assistance kind of thing. So this is, again, new this year, not required, but I do recommend it. It really will help your case, assuming they fill it out in a way that supports your case. Okay. So I also like to state that I generally say the doctor should have seen the individual within the last 6 months at least, because you don't want a doctor filling out a form when they haven't seen the patient in a very long time. Okay, step 2, filing a petition. So there is a lot of paperwork required with a conservatorship. In a moment, I'll show you a slide that shows some of the paperwork that's required. It is absolutely doable to do on your own. I don't want to say that that's not doable. Plenty of parents do this on their own. Okay, but there are a lot of documents required. The primary document is a petition where you are saying, I'm requesting to be conservator of this person. Now, okay, where are you doing this? When are you doing this? How does it cost money? Let's talk about just the basics. So you are going to do this in the county court where the individual who is being conserved lives. So if your child, and I know there's people on here that it might not be your child, but it's just easier for me to present this way. If your child lives in a different county from you, you're going to do this in their county, not in your own county, okay? And you're doing this in the probate department of the local county court. So when you go into any court and go to file documents at the filing windows, that's divided by, family law, probate, civil, all that kind of stuff. So this is the probate department. The probate department handles wills and trusts and guardianships and conservatorships. That's a question I get quite often is what is the difference between guardianship and conservatorship? Guardianship in California means someone who is under the age of 18. That is a child, a minor that needs, a new guardian, a new legal guardian appointed. Conservatorship applies to adults who are 18 and over. Okay, so that is the difference of that, because some states actually call conservatorship what we call conservatorship, they call it guardianship. So it can be confusing. Now, when do you want to file a petition? So conservatorship applies to an adult, someone who's 18 or over. So that means you can do it at any time that they're an adult. Okay, you can conserve someone at any age once they've turned 18. Or some people have very urgent needs and need the conservatorship to be in effect when the child turns 18. So in that case, you would start in advance. Different counties have different timelines, quite honestly. For instance, I just filed a petition in San Mateo County, and we have a hearing date in July. Okay, that is a long timeline. That is the longest timeline of any court I work with. But, somewhere like Marin or Sonoma, you're going to get a sooner date. Probably, Sonoma sometimes is as quick as 2 months, even 2 to 3 months. Marin is probably right now scheduling for maybe like June. So it just depends. Okay, it's going to be anywhere, I would say, from 2 to 6 months later that you're going to have a hearing. So you're going to want to take that into account and file your paperwork in advance enough so your hearing date will be close to the 18th birthday. Okay. Now, is there a cost? Yes. If the individual, though, is considered low income, and that means the individual being conserved, not you. If the individual being conserved does not have any income or assets, or is on public benefits such as Medi-Cal, SSI, SNAP food stamps, IHSS, any of those types of programming, then they automatically can have their fees waived. And you would just need to fill out something called a request to waive court fees. Okay, so you can have court fees waived. Otherwise, you do have to pay $435 to file a petition in the court. Okay, but if you can get your fees waived because the individual either receives public benefits or doesn't have income or assets, then you will not have to pay that fee. Okay, so let's move on. So all of these documents are required in all counties, but some counties require other documents as well. Okay, but this is a great starting list of the main documents that all counties require for conservatorship cases. All right, now all forms are available online. All right, so you can find all forms online. There are some great counties that actually give, like on their court website, really good information. I actually I'm not trying to plug myself at all, but I just launched a new website yesterday for my law practice. And if you go to it, it's just alexislynchlaw.com. There's a resources page, and I actually put some really good information on there of some courts that have great information about how to, where to find documents for conservatorships and how to do the process. So you can take a peek on there. But this is a very important starting point of the documents necessary. We're going to talk about some of these now. Okay, so notice of hearing. When you have a case in court that has a hearing, certain people have to be notified that the hearing is taking place, because if anybody wants to show up to object, for instance, they need to be given that option. So this is required by law. In a limited conservatorship case, these are the people that have to receive notice in the mail that the hearing is taking place, okay? The parents of the individual and siblings of the individual, all right? Now, if you're the parents and you're requesting the conservatorship, you obviously don't have to send notice to yourself. Okay, but if there's a parent that is not part of this process, they would need to receive notice. Living grandparents need to receive notice, okay? And again, this is just in the mail. Just have to mail them something to notify them about this hearing. And then the person being conserved is going to have their own attorney, and we will talk about that shortly. In many counties, it is the public defender's office that represents the individual, okay? Counties such as Sonoma, Marin, Alameda, Santa Clara, Solano, where else? Those are the top ones I can think of. Other counties such as San Francisco, Contra Costa, San Mateo, they use a private defender, and it's actually someone like me. It's an attorney that handles conservatorships all the time that asks to be part of their court's panel. I used to do it in San Francisco years ago. Okay, so if you are in a county that has the public defender's office as part of this process, you are required to mail the public defender's office notice of hearing. Okay, and then the regional center needs to receive notice. So they are on the list also that you need to mail notice to so that they know this hearing is taking place. And the regional center is actually involved in the process, which we're going to talk about. Oh, and that's a great question. Thank you. Yes, even if the relatives that I mentioned live out of state or out of the country, they still need to receive mailed notice of hearing. Now, let me be clear. Any relatives don't have to do anything. They do not need to participate in any way if they receive notice of hearing. You are just required by law to make sure that they are mailed the notice of hearing. Okay. All right. Let's continue. Step 4, citation. Okay, this is a quick one. Just the individual being conserved has to be actually personally served paperwork, meaning not in the mail, meaning like you see in the movies when it's like, you've got served, that whole thing. So someone needs to actually walk up to the individual, hand them paperwork, and then the person who did that needs to just sign a form saying, I handed them this paperwork at this place at this time, and sign it. And that needs to get filed with the court. Okay, so it can't be you because you're part of this, proceeding. So it needs to, you could ask a friend, a neighbor, someone at the school, but someone needs to do that. Even if the individual cannot read, even what it's required by law that someone hand them this paperwork. Okay. So let's talk about the attorney now for the individual being conserved. So the attorney, like I said, it's either going to be an individual from the public defender's office, and I mentioned some counties, or it's going to be someone like me, a private attorney who gives their time to the court's panel. Okay. Now, the idea behind this is obviously the individual who is going to be conserved, their rights need to be protected. So they are automatically appointed an attorney by the court. That attorney then is supposed to visit with the individual and try to engage them in a conversation. Now, obviously, some individuals are nonverbal and some are highly verbal, and there's everything in between. So, and that is neither here nor there when it comes to this process. The attorney is still supposed to meet with them, attempt to engage them, and discuss the conservatorship with them. Now, they are supposed to basically determine, does this individual understand what this conservatorship process is? And do they have opinions about these decisions that you are requesting to be able to make for them? Okay. And then they are supposed to, then basically voice the individual's opinions to the court. All right. So these, in my experience, and I've done this in many, many counties, it's, in my experience, the attorneys are very, very kind. They are, let's be honest, attorneys are not all the coolest people out there. I don't love attorneys and I am one, but these attorneys generally are very nice. They're not, there to like rile things up or create, some sort of like adversarial situation. So just know that I always like to try to, alleviate people's concerns with that. Okay. So the regional center, like I said, they are involved. So what the regional center is required to do by law is they actually have to submit a letter or a report to the court where they make their recommendation about the conservatorship. So they will, first of all, just write a description of the individual. And then what they do is they go through, let's say you've asked for all 7 of those decision-making powers I spoke about earlier. They are going to go through each of the powers you're requesting and make a recommendation for each one. All right. Now, quite often, well, I shouldn't say that. Certain, there's different regional centers, right? Different regional centers respond differently to the request for the controlling the social and sexual relationships and withholding consent to marriage. Okay, some regional centers have an understandably very strict policy that they don't want to recommend those unless there is a very real, need, like historical, events that have happened that show that it is necessary. Okay, so I'm just putting that out there. Now, it is important to know that whatever recommendations the regional center makes, those are not binding on the court. The court doesn't have to rule that way. So it's just another piece of the puzzle that they take into account. Okay. I do also want to point out our poor regional centers are incredibly under-resourced, as we know, and case managers have very large caseloads. So when you have filed your paperwork for a conservatorship, I always suggest reaching out to your case manager immediately and letting them know about the hearing date so they have plenty of time to prepare the necessary paperwork. All right. Step 7, our court investigator. So every single, I see that there's some, let's talk about that. Back to regional center for a moment. Great question. If the adult is not a regional center client, do they have to sign up to complete this process? Really good question. And unfortunately, there's not a black and white answer to that question. It kind of varies by county, but I will say, I do think when you're transitioning to adulthood, having regional center services is really important. They provide a lot of services that are going to come in handy for an adult with a disability. So I do recommend applying for services regardless. Also, some courts, yes, really want that paperwork from the regional center. Some courts, but however, the process to be found eligible for regional center services can take quite some time and could delay your case. So it really is reliant, it's really dependent at the end of the day. If you start that process and you have not finished the eligibility process by the time your hearing is, it's up to the judge what they want to do. Okay. And unfortunately, I can't give you like this is how it will play out because it can vary. Okay. Okay. All right, let's go back to court investigator now. And that's a good question. She's asking because some patients have been denied services from regional center. That is important. And that has happened to me many times with clients. If they're denied services, then the court usually will go ahead with the conservatorship process without the regional center because that's different. So if they've, that's a different animal if they've been actually denied. Okay. So back to court investigator now. You guys are asking such good questions. This is like a very engaged group and I'm very appreciative of it. So thanks for hanging in there with me. Okay, the court investigator, they are an employee of the court whose job is to basically investigate the whole case and give all the information that the court will need in order to make a ruling and decide if this conservatorship is the way to go, right? So what that looks like is, and it does vary county to county. Some counties have a lot more resources than other counties. Some counties have more court investigators than other counties, in which case they have more, ability to do a kind of a deeper dive. Other counties have barely any investigators and are just barely getting through their caseload. So it really depends. But the very basic things that they will do at the very least is they're going to visit the individual being conserved and see where they live, make sure it's a healthy environment, that they have access to what they need. Is there clean clothing in a bed, and they're being fed, and all that, those basics, right? And then they also are going to want to interview the individual. Same as the attorney, where yes, this individual may be nonverbal, may be highly verbal, whatever it is, but they're going to try to engage them, try to discuss the conservatorship and determine, do they understand this and do they have an opinion about it? Now, the court investigator is also going to interview you though, because you are part of this process. they're not only focused on, is this conservatorship necessary, but they're also focused on, and are you an appropriate person to serve as conservator? So they do a few things. They run a background check on you. Okay, you do need to submit a very thorough screening form that gives, your social security number, your driver's license number, all that information, so they can run a background check on you and see if there's anything on your record. They're going to interview you, and they're going to talk to you about, anything from like, where did you grow up, and what do you do for a living, and how are you involved in this person's life, and all of that kind of stuff, right? And they're also going to ask you a lot of information about the individual and the history of their disability and how it presents itself. So that is the job of the court investigator. They may also interview other people, though, and this is where it comes into play of how, of their caseload and their resources. A lot of times they'll interview the regional center as well. Sometimes they'll interview other family members that are, close, like a sibling or something that lives in the home or something like that. And sometimes they'll interview like a school they attend or a day program they attend. So it just really varies. And then what happens is, at the end of all of this, they put together a report for the court that says, here are all the interviews I did, and here's what people said. And, and I didn't find anything on a background check that's worrisome. And then you get a copy of that report so that you can see where things stand, basically. Okay. So let's talk about the hearing now. All of this is leading up to a hearing. Do you need to be at the hearing? So first of all, hearings are still being conducted this way, remotely. You can sit on your couch and attend your hearing, which is pretty amazing. So that started during the pandemic, obviously, and it's still going, which is great. Some courts, you do need to file something stating that you're going to be remote. Fresno is very strict about that requirement. But, a lot of courts have zero requirement of that, and you just show up on Zoom. So now, yes, you need to be at the hearing, and your child is supposed to be at the hearing as well. The judge will want to see their face and make sure that they are, part of the process, participating in the process, even if they can't speak or communicate with the judge, or, or are not even really paying attention. I've had clients whose kids are, just kind of walking back and forth in the background. So now the hearing, ideally, you have your investigators report ahead of time. You've seen the regional center's report, you have spoken, to the investigator, and you basically have an idea like, okay, there's no red flags that have come up here and everything's looking good. Then really the hearing is going to be more just a formality, where the judge needs to see your face, needs to see the face of your child, and then we'll sign paperwork and send you on your way. Okay, that's the ideal. Now, if there are any things that need to be addressed and any questions the judge has, they're going to ask them to you at that time, and you'll have to answer them and give the judge the information they want. What happens at a hearing? We just did that. Okay. Letters of conservatorship. This is your golden ticket at the end. You need to have the court issue something called letters of conservatorship. It's after the judge has signed the order and it's been filed. Then the court can issue this letters of conservatorship, which is what you're going to show to a doctor, to the school, to the regional center, that shows that you are conservator, and it shows the decisions you're allowed to make. Okay. And you're going to want to, I always say, ask for a certified copy. A certified copy means that they put a very special type of stamp on it. So, and what you're going to do is you're always going to keep your copy, and you can show it to people and they can make a photocopy of it to keep for their file, but you want to hold on to your original. Okay, so now it's after the hearing, you're conservator, you're almost done, because there are some more documents that are necessary. This one I have not totally updated yet. So I just realized. So notice of conservatee's rights, you have to mail all those family members that you had to mail earlier. You have to mail them again. And it basically is letting them know that the conservatorship is in place now. And then there's something called a determination of appropriate level of care. This is actually now called Conservatee's Care Plan or something like that. And there are actually two. It's part 1 and part 2. Okay, so this slide is outdated. So they are just basically questions about the care that the individual receives that you need to answer and then file with the court. And then a lot of counties have something called a general plan. The general plans that a certain county may have is very similar to this new care plan form. So I'm curious to see if the courts that have general plans, if they're going to get rid of their general plans now that this new care plan form has all that information. We'll see. But the court will give you a deadline at the hearing about when you have to have all these forms completed by. Okay, so now you're really done. You've done the last forms and you're really done. So, okay, what's the maintenance of this? So the court is going to supervise your conservatorship. Ideally, the timeline they use is after the first year, and then every 2 years thereafter, a court investigator is going to conduct a review where they visit the individual, make sure that their needs are being met, and they'll interview you and just discuss what's going on with the individual. Okay, so those are ongoing ongoing check-ins that the court is going to do. Some courts, like Alameda, for instance, require annual status reports where you have to just fill out like a simple, like a one-page form updating the court about the individual's needs and things. And you're supposed to do that annually and just submit that to the court. So it just depends on your county, really. And then let's see. Okay, what if you move? This is always a question I get. So if you move out of county and stay within California, then you do need to have the case transferred to the county that you're going to be in so that court can supervise it. Okay. If you're going to move out of state, you are supposed to get permission, and there is actually a document for that you file with the court requesting permission to move out of state. Okay. If you do move out of state, your limited conservatorship does not transfer to the new state. So you would need to start this process in the new state because different states have different laws around this specific type of conservatorship for individuals with developmental disabilities. And even if you move just within your county, you do need to update the court of your address. Okay. And we are almost done. So this now we're moving, this is just a quick, like, hey, do you know about public benefits? Because you should. So, oh, this isn't updated to 2025. Look at that. So supplemental security income, SSI, is a public benefit that you can apply for when your child turns 18 so that they can receive a monthly payment from the government. California also kicks in a little on top of it so that it actually bumps it up from 2024's amount was 943. 2025's is probably like 950 something. I can't quite remember off the top of my head right now. Anyway, but this is something you can apply for if your child has a disability and is unable to work, and they can receive a monthly payment. And then Medi-Cal, is also obviously a great option for medical insurance through California's Medicaid program. And these are two things you're definitely going to want to look into for your child once they are an adult. Now, let's talk about down the road. How do you prepare for that? So first of all, you are not going to be able to be conservator forever. You have two options. Number one is just have a simple document where you have nominated who you want to be conservator after you. I suggest it should be a signed formal document. I suggest having it notarized, the whole thing. And then what happens is, let's say something happens to you. That doesn't mean because you have this document that now that person just becomes, they're like, oh, well, now that person is conservator. No, that's not how that works. Instead, what happens is that person goes to court, goes through a similar process of what we just discussed, not quite the same process, but a similar process, and has that paperwork to show to the court to say that they were the intended next in line. Okay, so that's one option. The other option is, having a co-conservator brought on, which I discussed earlier. So for instance, I'm helping a very, like a 90-something-year-old mother right now have someone appointed to be co-conservator with her so that when something happens to her, there's already a conservator in place. Okay. If you are leaving an inheritance to your child, you are going to want to set up something called a special needs trust so that the child, first of all, doesn't just have a lump sum inheritance that they don't know how to manage themselves. So you can put someone else in charge of that money for them. And number two, you don't want them to become ineligible for public benefits because SSI, for instance, is dependent on how much money they have, and it's a $2,000 limit. So if they receive an inheritance, now they no longer get to receive their SSI. But if it's put into a special needs trust, this inheritance, that protects their eligibility and they can still receive their SSI benefits. So that's a very 2-second explanation of special needs trust, but I highly recommend looking into that for your own estate plan. And then also ABLE accounts. Look into ABLE accounts. They're amazing if you haven't heard of them. It's a way for your child to save money in a tax sheltered savings account, and they can save up to $100,000 and still preserve their eligibility for SSI. So the ABLE accounts, great things. This is me, and let's see. Okay, I'm gonna open it up. I'm gonna check the chat real quick and see if there's any things I can answer quickly. Does a co-conservator have to be interviewed by the court investigator and or public defender? Great question. So let's be clear, the attorney for the individual, they do not interview you. They're only interviewing their client, and their client is the person being conserved, okay? The court investigator, though, is interviewing everyone, and yes, they will generally want to interview both co-conservators. In every county, does it happen? No, but yes, in an ideal world, yes. Okay. If the hearing is via Zoom, how do you get your letters of conservatorship? Great question. You can either go to court in person to the filing office to pick them up, and or you can, when you submit everything and have everything filed, you can give them a return envelope with a self-addressed stamped envelope, and they can mail it to you.